So I want to talk a little bit more about Vigil v. People. This is a 1960 Supreme Court case, a Colorado Supreme Court decision for gun rights and the principle of self-defense. First, I want to talk about the Second Amendment and then Colorado's version of the Second Amendment, which is Article 2, Section 13. And the Second Amendment is a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Section 13, right to bear arms, a right of no person. This is Colorado's Second Amendment, quote unquote Second Amendment. Section 13, right to bear arms. The right of no person to keep and bear arms in defense of his home, person, and property, or in aid of the civil power, when thereto legally summoned, shall be called into question. But nothing herein contained shall be construed to justify the practice of carrying concealed weapons. Now, that's the exact same language that it was when it was written in 1876, the Second Amendment to the U.S. Constitution, 1791. So the exact same language. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In Section 13, the right to bear arms, the right of no person to keep and bear arms in defense of his home, person, and property, and in aid of the civil power when thereto legally summoned, shall be called into question. But nothing herein contained shall be construed to justify the practice of carrying concealed weapons. So, with those two as the bedrock foundation for a Colorado American's right to keep and bear arms, let's talk about the Vigil decision. So 1960 Vigil v. People. 1960 Vigil v. People. This is a killing, a murder that took place right here in the San Luis Valley in Conejos County in Capellan. The Vigil decision says that you got a right to defend yourself up to the point of a deadly attack if a person attacks you, or if a person attacks you and they threaten to attack you again. And that stands your ground. That stands your ground. Juan de Dios Vigil walked towards Ralph Valdez. He walked out of his house onto the road to go visit his daughter. And in the middle of the road, you had Ralph Valdez and a bunch of other, hooligans drinking or whatever on election day. Ralph Valdez, a terrible ill repute who had robbed Vigil at least once before on a road outside of Capellan, and Ralph Valdez is going to attack Vigil. So Juan de Dios Vigil walked out of his house and into the road, and just because he got into an argument with Ralph Valdez, that doesn't mean that Ralph Valdez gets to commit a crime against him, and Vigil had a right to defend himself. So the court explicitly rejected in Vigil. They talk so much, with the whole Rittenhouse case. There is a law that says if you're under 18, you can't have a gun, I think, or I don't know, maybe an assault weapon. I think there's an assault weapons ban across the board. So on that part, Rittenhouse would have been still guilty. But Rittenhouse, in terms of self-defense, they're going to say lots of things, actually, because they said that they gave instructions to what self-defense was, and they didn't agree with those instructions. Vigil. The Vigil decision, the 1960 Vigil decision, also doubled down on the right to self-defense up to justifiable homicide in defense of person. Here's a quote from the 1960 Vigil decision. The law is that the one invoking the right of self-defense cannot be the aggressor or the assailant, but the mere fact that one has interjected himself into a crowd or into a mild situation does not deprive him of the right of self-defense. If the situation, beginning only with an argument, develops to a point where he is being subjected to or threatened with such physical violence that he might have to resort to justifiable homicide to protect his person. 1960 Vigil continues. The statement in the instruction that the right to defend himself is based upon what a reasonable person would do is also misleading and confusing. The right of self-defense is a natural right and is based on the natural law of self-preservation. Being so, it is resorted to instinctively in the animal kingdom by those creatures not endowed with intellect and reason, so it is not based on the reasonable man concept. So the instruction said that if you were Vigil, would you have done what he did? Was that what a reasonable man would have done? And they said, well, that's actually misleading because the right of self-defense comes from the animal kingdom. It's instinctive. It's instinctive. It's not based on reasonable man. It's based on the natural law of self-preservation. The natural law of self-preservation. So when it comes to Rittenhouse, people saying that he interjected himself into a mild situation, it wasn't a mild situation. But just because he was there in the middle of the chaos, does that mean he doesn't have a right to defend himself? Of course he's got a right to defend himself. And then when it comes to, not just he's allowed to interject himself into the situation, but when it comes to the right of self-defense, is that what a reasonable man would have done? Walk into a chaotic situation with an AK-40, with a AR-15 or whatever, seeing if anybody would mess with you? Is that what something a reasonable person would do? Maybe, maybe not. But it's not based on the reasonable man concept. It's based on instinct. He was there. He had the AR-15. And actually, since he wasn't allowed to have the weapon, that should have been the way that the prosecutor or whatever defense should have gone. Because he wasn't allowed to be there with a weapon. He was, 17 at the time. So he was breaking the law. He was breaking the law. But they threw that, thing out and just dealt with the murder charge. And so I guess if you beat the murder charge and all the other... So, let's assume he was allowed to be there. If he was 18. If he's 18, he's allowed to be there with an AR-15. Somebody attacks him, he has a right to defend himself. Now, 1960 Vigil, they combined a whole bunch of CRS back in 53. And they defined justifiable homicide. They define justifiable homicide as the killing of a human being in necessary self-defense or in the defense of habitation, property, or person against one who manifestly intends or endeavors by violence or surprise to commit a known felony, such as murder, rape, robbery, burglary, and the like, upon either person or property, or against any person or persons who manifestly intend and endeavor in a violent, riotous, or tumultuous manner to enter the habitation of another for the purpose of assaulting or offering personal violence to any person, dwelling, or being therein. A bare fear of any of these offenses to prevent which the homicide is alleged to have been committed shall not be sufficient to justify the killing. So not just a fear, it must appear that the circumstances were sufficient to excite the fears of a reasonable person, and that the party killing really acted under the influence of those fears, not in a spirit of revenge. And if the person killed was a magistrate, a police, or other public officer, it must appear also that the slayer was not the assailant, and that the person killed was not acting in the discharge of his duties. If a person kills another in self-defense, it must appear that the danger is so urgent and pressing that in order to save his own life or to prevent his receiving great bodily harm, the killing of the other was absolutely necessary. And it must appear also that the person killed and in good faith endeavored to decline any further struggle before the mortal blow was given. So from Vigil, v. People, the 1960 Colorado Supreme Court case, we have a right to self-defense. We have a right to self-defense. And even though they say it's based on the natural law of self-preservation, they did, drop some reasonable thing in there. Not just a bare fear. It's got to be more than just a bare fear. It has to be, really that you were, afraid, and that afraid were sufficient to excite the fears of a reasonable person. And it wasn't in a spirit of revenge. Now, if it's a police officer, right, they couldn't be killed in the discharge of their duties. So there is an exception for police officers or a magistrate or other public officer. So Vigil v. People, 1960, that stands your ground. That stands your ground. And when it comes to Colorado gun laws, there's a lot of restrictions. There's red flag laws and other laws. But there's also a lot of freedoms. All Coloradans have extreme castle law, posse comitatus rights, a make my day law, an extreme stand your ground and stand others ground law, no duty to retreat. We got open carry here. We got citizens arrest. And in Colorado, we have a right to revolution. Now, the question that I could not really totally answer, but I think I'm pretty clear on it, was we got an extreme right to defend our home, and we have an extreme right to defend our person in Colorado, but do we have an extreme, not absolute, or do we have a maximum right when it comes to the right to bear arms in defense of property? Because there's one statute that says that if they're robbing you, then you can't use deadly force unless they're threatening your person or somebody else's person. And so that makes an exception that, property, they could rob you. And if they just walk past you with, your stuff in their hands, but they're not threatening you, well, you can't, just shoot them. They have to be running at you. They have to be, attacking you or threatening a person. But that's a statute. When it comes to property, all over the place, even in Vigil v. People, in both the Colorado and the U.S. Constitution, we have a right to property. The life, liberty, and the pursuit of happiness, which is property, right? That's John Locke, life, liberty, and property. And so ultimately, when can you use deadly force if they steal your vehicle? If they just take a penny, I could understand that's like nothing. But then there's the principle of the thing. So a penny, yeah, I could understand. And then is it the value? And then is it the value to the person? Because what, is worth $100 to one person could be worth $1 million. So, yeah, just that was all over the place. You have constitutional protections when it comes to the right to property. And so since we have a right to bear arms for self-defense, for home, and for person, since it's interpreted broadly, that indicates to me that the right to bear arms in defense of property is also interpreted broadly, constitutionally speaking. So if you put that, legislative statute off to the side, just take it and just put it off to the side. The Constitution is very clear that you have a right to defend not just your home and, person, your person and other persons, but you also have a right to defend property. You also have a right to defend property, meaning that if, Kyle Rittenhouse, they said they want to take his gun there, he was defending his gun. He was defending his right to own property. Or if they're trying to take Skittles, right, out of someone's hand. I was going to say a couple things. I once saw this video where the guy was trying to steal somebody else's crotch rocket, a motorcycle, right there in the middle of the street, right there in broad daylight. He was sitting there at a red light. Somebody put a gun to his head, said, "Get off the bike." And as he was getting on the bike, the guy pulled out a gun and they shot and killed the guy who's trying to steal his bike in the head. And that is just totally right and just. He pointed a gun to him, threatened his life, was going to steal his property. Once he stole his bike, he was gone. But that guy jumped off and, shot the guy, and that was total self-defense. Now, Rand Paul, he once floated the idea that you can drone strike somebody stealing, a fifth of vodka out of a liquor store. So for $20, you could drone strike somebody? I think that's not proportional, but I think constitutionally it would be justified. So the spirit of the Colorado laws, again, we have an extreme and maximum freedom. We have an extreme maximum freedom when it comes to the use of arms and self-defense to defend people, persons, ourselves and others, and our home and other people's homes. But when it comes to property, like I said, there's that, one little tiny law in the criminal code, Title 18, that says if they're, doing burglary or criminal mischief or basically property crimes, but felonious, right, big property crimes, that unless they threaten your person, then deadly force cannot be used. So besides that one exception, which I don't know, is that unconstitutional, or do we just say the spirit of Colorado laws says we have extreme maximum freedom in defense of home and people, and there's some exceptions for use of arms up to using deadly force in defense of property. So there's no question, right, whatsoever in the Constitution. It says you can't even question my right to own a gun in defense of property, people, and home. But the statute says, well, maybe one question. We'll have one question. So it seems to me that the spirit and the main thrust of Colorado law is you have probably, let's see, not an absolute. There's no such thing as absolute freedom and absolute power. They're both against each other, right? So they should knock each other out. But yeah, the goddamn Constitution says you can't even call it into question. So what the hell is the legislator? Why are they calling it into question? Anyways, that's a little bit on People v. 1960 Vigil v. People.